So today I'm going to be talking about the changes to Companies House. I have a small confession to make. I set this one up as the first presentation in the new year because I delivered a presentation on this at SESCA in the autumn, which was itself based on one I'd done on a coffee break briefing about 18 months ago. And I thought I could be really lazy and just blow the dust off the previous presentation, make a couple of small tweaks to it and get away without too much in the way of preparation for it. But once I started looking at it and I could see the changes that are already being implemented and the significant ones that are going to be brought in before the summer of this year, I thought that really wouldn't be fair, and I think I need to focus on those particular changes just to help you make sure that you are as prepared as you can be for them. So that's really what I'm going to be focusing on this morning. There are three broad topics I'm going to be covering. First of all, I'll give you a quick overview of what is changing at Companies House and why. Then I'll move on to look at when the changes have taken place and the ones that are going to be coming into force, in some cases really quite soon. And then I'll look at three specific aspects: official email addresses, ACSPs, or authorised corporate service providers, which I will say a bit about. I think they're going to be quite important for the insolvency profession. And I'll talk about unverified directors, as I think they too are going to be quite important for the insolvency profession. So let's move on to the overview and just give you a quick summary of what's changing and why. Essentially, the biggest changes in Companies House's history, and it's being done through the Economic Crime and Corporate Transparency Act 2023, which I won't refer to again because that is simply making a lot of changes to the Companies Act. So the law itself is going to be found in the Companies Act rather than anywhere else. And broadly, what the changes are about are to make Companies House a register of record so that you'll be able to rely on the information at Companies House. If somebody is listed as a director at Companies House, you can be sure that they are a director in law. And if somebody is not listed as a director, they won't be entitled to act as a director. And the changes are along those sorts of lines to try and ensure that the information that we lift from Companies House is accurate and reliable, and that Companies House is less able to be used as a way of committing fraud. So let's move on now to look at the timetable of changes. And the first changes took place in early 2024. That was the change to email addresses. It's been possible to register as an authorised corporate service provider, an ACSP, since March last year. And voluntary ID verification came in spring last year, and since late November last year they've been phasing in the introduction of compulsory ID verification for directors and others. The first of the big changes that is coming, and this is the one that I think is going to be most significant for the insolvency profession, is that before summer this year it will become essential for everybody who is filing documents at Companies House to have their identity verified. And that is going to apply to insolvency practitioners. So that is the big change, is that you're going to need to have your ID verified to carry on filing documents that you are required to file as an insolvency practitioner. And the identity requirement for directors and others is already being phased in, and that's over a 12-month period. And by the time we get to the 18th of October this year, all directors at Companies House should have their identity verified. So turning that one around, that's probably the date when we're going to hit peak unverified directors, I'll be talking about the consequences for the insolvency profession of dealing with unverified directors a bit later on as well. So that's the timetable of what's happening when. There are now these three things I want to focus on: email addresses, ACSPs, authorised corporate service providers, and unverified directors. So the first of those are email addresses, and every registered company should now have an official email address. Now this email address, it's a bit like a registered office, but it is for only Companies House to use. It's not one that Companies House would publicise or encourage other people to use or authorise other people to use. It is just for Companies House to send communications to that particular company. So things like a notice of striking off is likely to be sent on that email address. And I think that just as you change the registered office on appointment, you're likely to want to change the official email address on appointment so that those official emails from Companies House are coming into an account that you have access to and which you control. And there are some minor policy decisions for you as an insolvency practitioner, for example, about whether you might use a single email address for this purpose across all of your appointments. And if you're doing that, whether it'll be a personal email address that's being used or some sort of generic email address. And the generic email address, of course, could go to several people who work with you. And you might also decide as a matter of policy that you're not going to be giving that email address to anybody except Companies House, so that pretty well everything that comes in on that email address should be just official notices from Companies House. So that's about email addresses. The one that I think is going to be important to know about are authorised corporate service providers. I think this is going to affect the way that you work as an insolvency practitioner. And an authorised corporate service provider, an ACSP, is essentially an organisation that Companies House trusts to file documents and to verify and certify the identity of the people whose documents they are filing. So effectively, Companies House will be subcontracting the verification work out to an ACSP for all documents that are filed through the ACSP. And within the ACSP, you will have to organise verification procedures and record-keeping arrangements so that all documents that you file to Companies House through the ACSP, there's a proper audit trail of who it was who actually approved the document, who signed it, and who filed it. You can already register as an ACSP. Frettons is already registered as an ACSP. And because everybody who files documents at Companies House will have to be verified before the summer of this year, then you're going to find an awful lot of ACSPs being used, and I'm emphasising them today because I think you might find that registering as an ACSP or using an ACSP may be the most convenient way for you as an insolvency practitioner to continue to comply with your filing obligations. As I understand it, there are three options for you as an insolvency practitioner for filing documents at Companies House for when verification comes into force for you before the summer of this year. Option one is to use your own personal ID verification. So you have your own personal account at Companies House. Option two would be for you as an insolvency practitioner to set yourself up as an ACSP, which would authorise you not only to register your own documents, but would authorise you to register documents on behalf of others. And option three, which I suspect is probably the one that most firms will go down, would be for the firm itself to register as an ACSP, so the firm can verify the ID of people filing documents in the firm's name, where the firm is filing on their behalf. So looking at each of those in turn, start with individual ID verification for yourself with a direct personal account at Companies House. If you are a company director or a member of an LLP, you're going to have to open your own personal ID account at Companies House anyway, if you haven't already done so. And the filings that you make as an insolvency practitioner will be linked with that personal account you've got, so it will show you as being the same person. And if you go down this particular route of your own personal ID registration and filing in your own name, this will allow you not only to file your own documents, which will be things like your notice of appointment and your annual reports and returns, but it will also allow you, in your capacity as an officer of the company over which you've been appointed, it will allow you to file on the company's behalf. So you will be able to file, for example, the special resolution to wind the company up. Your capacity as liquidator and therefore officer of the company, you'll be able to file a change of registered address in that capacity as well. And you will be able to ask Companies House to add your colleagues at work to the insolvency filing database so that they will be able to file documents on your behalf. And R3 circulated a technical alert a week before Christmas about this, which I would recommend you have a look at. One limitation to this, to authorizing colleagues to file on your behalf where you've got a personal ID account at Companies House, is they won't be able to file documents on your behalf as an officer of the company. So they'll be able to file the notice of your appointment, they'll be able to file the annual reports that you make. They will not be able to file the special resolution winding the company up. They will not be able to file a change of registered address, and there could be problems if there's a joint appointment with you, because they won't be able to file on behalf of the joint appointee unless the joint appointee has also named them as being able to file on their behalf. So I think that could be quite a cumbersome way of doing it. Registering yourself as an ACSP will allow you to give broader authority to colleagues, so they will be able to file not only on your behalf, but they'll also be able to file on behalf of the company over which you've been appointed, and they'll also be able to file on behalf of the joint appointee, even if the joint appointee is from another firm. And those colleagues won't need personal ID verification at Companies House. If you authorize people to file on your behalf with a personal account, at the moment they won't need personal ID verification, but they may need ID verification in the future, as Companies House may introduce that. If you register as an ACSP, the point is that you actually accept responsibility for verifying the identity of people who are filing on behalf of the ACSP, and Companies House will accept you as having done that. The third option, which, as I said, I think is the one that is probably going to be most convenient for most insolvency firms, is for the firm itself to register as an ACSP. I'll move on now to talk about unverified directors and the issues around those. And these are the new rules. Well, the existing rule, of course, is that directors have to register their appointment at Companies House. That's not changing, except there is much more emphasis on the mandatory nature of this and the consequences of not doing so. And in addition, directors not only have to be registered at Companies House, but their identity has to be verified at Companies House. These changes are being phased in from November last year, so they will apply to all newly appointed directors and directors who are already in office November last year. This will apply to them at the point when their company's confirmation statement, its annual return, needs to be filed. They'll then have a short period of time to get their ID in place. So there's a lot of pressure on directors to get on and get their ID verified sooner rather than later, rather than rush to do it when the trigger date actually arises. Consequences of having an unregistered or an unverified director if they haven't registered a Companies House, their powers do not come into force. Until they've actually registered their appointment at Companies House, they are not allowed to act as a director. So they're a director in name only. And there's a very similar rule to directors about the verification of their identity. So once they've been appointed, they cannot act as a director. They do not have any power to act as a director until they have also verified their identity at Companies House. They have to do both of those things: register their appointment and verify their identity. And only once they have done both of those are they actually legally able to act as a director. And I said that is being phased in from the 18th of November. If they breach either of those rules, it's a criminal offence. And the Companies Act goes on to say, although it's a crime, it is nothing more. What the Companies Act actually says is that those offences are the only consequences of contravening the obligation to register and the obligation to have your identity verified. And the Companies Act goes on to say that, for example, a contravention does not in any way affect the validity of an individual's acts as a director. So that, I think, raises some quite interesting questions about what you might do if you find yourself dealing with a company where there's an unverified director who's obviously been acting as a director when they should not have been doing so. Well, it's pretty clear that you're not going to be able to set aside transactions that they entered into. They may have sold the company's assets pre-appointment when they were not verified as a director and not entitled to act as a director. That sale is still going to be valid. You can't claim the assets back from the purchaser. You can't say it was not a valid sale. You have to accept the validity of it. But will you report that breach on your D report? Will you report to the disqualification unit that this particular director was acting as a director when they were not entitled to because they were not verified? Of course you will. Will it be a disqualification issue? I suspect it probably will. In persistent breaches of companies' legislation are disqualification issues. And I think if the disqualification unit found a director who had been running 4 or 5 companies and hadn't bothered to verify their identity for any of them, I think they might well want to make an example of them. What about bringing civil claims? What are your options here? The legislation says that for a director to act as a director when they are unverified is a crime but nothing more. Does that mean that you cannot bring a claim against them for misfeasance? You cannot bring a claim against them for trespass, a claim against them for breach of statutory duty? I think that probably you would be able to bring those claims. And my reasoning is that the legislation says that the failure to register, the failure to verify, is itself a crime, but with no further consequence. But you're doing more than that. You're then also failing to not act as a director. So I think there is something over and above the simple failure to register, the failure to verify, that gives you the chance to make a claim. And the reason why I've listed trespass there is by analogy with the situation that we used to get concerned about when receiverships were much more common, that a receiver who was not validly appointed would be a trespasser if they started to deal with the company's property, if they took possession of the company's property, if they sold the company's property and they weren't validly appointed. They could be at the end of a civil claim for trespass. And I think that the same thing could also be the case for a director who is not entitled to act because they've not complied with their duties to register or to verify their identity. I think there's at least an argument for saying that there could be a claim brought against them as a trespasser. Now, I know that there's at least 1 or 2 people from some of the leading litigation funders who watch these these presentations from time to time. So I'd be interested in their perspective on all of this, and whether they are thinking about the possibility of bringing claims of this sort, whether they might even have been talking to council about whether there are claims of this sort they might be able to bring. So those are the issues. It's a criminal offence to be a director or to act as a director when you're either not registered at Companies House or Companies House has not verified your identity. But these have further consequences as well, and I think we need to think about the consequences from the perspective of the anti-money laundering legislation. So if you see a director who is unregistered or unverified, firstly, the way the legislation is drawn, this is likely to be a crime by the company as well as a crime by the director. And if so, then all of the company's assets are likely to be criminal property for the purposes of the money laundering legislation. And when you come across criminal property professionally, you're quite likely to be under an obligation to file a suspicious activity report. And not only that, but if you're likely to have that property, the company's assets, coming through your hands in any way, you may also need to ask for a defence against money laundering offences to be able to do your job properly. So these are all money laundering issues that you're likely to have to think about. And it's not just us as lawyers, you as insolvency practitioners, who are going to be thinking about these issues. The banks, for example, are also likely to have to be thinking about these issues. And so I think it's quite possible that the banks might feel that they have to freeze the accounts of companies if they have a director who is unregistered or unverified for more than, I think it's about 14 days they're allowed to sort this out. And I think that the banks themselves may find that they have to do that to comply with their obligations. Now, I've been talking about the obligations on directors to identify themselves and to register themselves at Companies House. There are already similar obligations on significant shareholders, persons with significant control, to register themselves and to verify their identity. They've had to register themselves for quite some time. We've been used to company searches coming back with the lists of people with significant control of a company. But this is going to be more stringently policed in the future, with the obligation not only to report persons of significant control, but also for those people to verify their identity as well, in the same way that shareholders have to do so. So a person with significant control, mainly they're going to be shareholders with 25% or more of the company's shares or the voting rights, but they can also be somebody who controls, who is appointed to the board, or they can be somebody who has real influence or control over the company, which is fairly imprecisely worded, or they can be somebody who controls something like a trust, which itself would be a person of significant control if that trust was an individual. So it's pretty broad and not terribly easy to interpret who is a person of significant control. And by happy coincidence, it was just last week on the 5th of January that Companies House published a statutory guide to interpreting who is a person of significant control. So if you need to look into this in more detail, that's probably a good place to start. So as I said, these are rules that are being phased in over 12 months from the 18th of November 2025. And I think we're going to hit peak unverified directors about November this year, as it'll become very difficult for new directors to be appointed without verifying their identity, but existing directors may not comply very promptly, and so you might find that November this year is when we hit peak unverified directors. It'll be more common then than at any other time. So those are the topics I've covered. I won't run through them now. I can see that there are some questions that have already been raised, so I'll just have a quick look at those and see if I can pick those up in the next 2 or 3 minutes. So interesting question here from Joshua Currier, who asks whether director ID documents can be requested from Companies House, and will these be provided? I'm not sure that Companies House themselves will keep the ID documents. As I understand it, the ID verification that Companies House will be running will be through a one account, a sort of citizens account that's run by the government independently of Companies House. So I don't think the records are going to be there. There was a recent provision last year that came into force with Companies House that does allow insolvency practitioners to ask Companies House to provide documents that are not on the register. So if Companies House does have any ID documents, then you could use that provision to get hold of the ID documents. I think you'd have to, if they, first of all, I think the problem is that Companies House simply may not have them. And secondly, if they do have them, I think under GDPR, you'd have to persuade Companies House that you have a legitimate interest in having them. So I think the short answer to that is, in theory, possibly you might be able to request them, but as a practical issue, it might be very difficult to do, and Companies House may not be able to comply. Rob Russell has asked, how will we know if a director is verified or not? Will directors be removed from Companies House records if they are not verified? And will they be treated as having resigned if they have not been verified? Really good questions. First one is that you will know if a director is verified or not from your company search, because that will tell you what date the company director needs to be verified by and whether they have been verified or not. So it should be really easy to find out from a company search whether a director has been verified or not. Will they be removed from Companies House records if they aren't verified? I don't think they will be, because I think, as I understand the way the legislation is working, they will be a director, so they will have all of the obligations of a company director, but they will not be able to act as a director. So they'll be in this happy situation of having all of the obligations, all of the responsibilities of a director, yet none of the powers. So they will still be on the record at Companies House as a director with this note saying they haven't been verified. And therefore, to those who understand what this means, that means that they are not entitled to act as a director. And so the third question, will they be treated as having resigned? No, they won't be treated as having resigned. I mean, I guess you might have employment lawyers might set up employment contracts in such a way that if somebody is appointed as a director and they don't verify themselves, they will be treated as having resigned, and they can then be removed as Companies House. But I think that will be a separate issue. They won't, as a matter of law, be treated as having resigned. They will still be in office, but with no useful powers. So Robert Young has also asked, will it be immediately obvious which directors are and which ones are not verified? Well, yes, it will be immediately obvious, because they will have this note saying what date they need to be verified and whether they have been verified. Mark Newton asks a really good question. Will it be tipping off if you advise a director to verify identity pre-CVL? I don't think it will be, just as long as you say to them, look, you've not been verified, you've got an obligation to be verified, you won't have any powers to act if you remain unverified past that date. It will cause me considerable difficulty if you are unverified beyond that date, because I'm not sure I'll be able to carry on taking instructions from you. What you mustn't go on to say is, and by the way, I will be reporting you for money laundering offences from that point. So I think you can tell them what their basic obligation is and what some of the consequences are. I think that should be in order. Mark Darby asks an excellent question. Aren't unverified directors shadow directors? I did wonder whether to talk about shadow directors today or not, because I find this a very complicated and potentially confusing area. I mean, a shadow director is somebody in accordance with whose instructions the board is accustomed to act. So a shadow director is not quite the same thing as a de facto director. A de facto director is somebody who is basically doing the job of a director, but has not actually been, they've not actually complied with the paperwork, so they haven't been registered at Companies House. And I think an unverified director might be a shadow director, or they might not be a shadow director. I think it's going to be more common that an unverified director will be a de facto director. And an unverified de facto director is going to be somebody who hasn't been registered at Companies House, so they'll be in breach of both of the offences, the failure to register and the failure to verify their identity. So they will have the book thrown at them. A shadow director who is not a de facto director, so this is somebody who is perhaps an investor who's got a lot of influence over the board of directors, is pulling their strings because perhaps contractually they're able to remove them, or they've got a lot of contractual power over them, but they're not actually a director themselves. That shadow director is not necessarily going to be a director themselves, and I don't think a shadow director has to register at Companies House or has to identify their identity. Now, I think a shadow director in a situation like that might also be a person of significant control, and so they might have to verify their identity and they might have to disclose themselves on that basis. So it may be that if you're trying to hold a shadow director to account, then you might be doing so by challenging them as having been a person of significant control. And I think that's where you're going to need to be looking at this statutory guidance that the Companies House published just last Monday. Let's see. I think that's all of the questions that I've had. So oh, hang on, yes, and I've got a couple more since then. James Knight, another really interesting question. For companies in liquidation or administration already, are those directors required to complete ID verification? And if so, does the office holder have any responsibility for this? I don't remember seeing anything in the legislation that is specifically about this. I mean, Companies House generally have the policy that once a company is in administration or liquidation, the normal rules about filing documents cease to apply. And I think that's probably how Companies House are likely to interpret this particular obligation, as saying that essentially it's of no great importance if a director has failed to verify or failed to register themselves, because their powers are suspended anyway by the liquidation or the administration. And I've not seen anything to suggest that the office holder would be responsible for verification of that. So no, I think that should be all right. I think you can, I don't think there's anything you need to do about that. Colin Morris asks, does the legislation apply to LLP members? Short answer is yes, it does, in very much the same way. And Amanda Ireland asks, if a non-verified director verifies before being appointed as a liquidator or administrator, does that stop the funds in the bank from being proceeds of crime? I think I think it's going to depend upon the timing of it. So I think the director's got 14 days to verify. So if they verify within those 14 days no criminal offence has been committed, and the funds are not proceeds of crime, I think if they verify their identity after 21 days, so that you've had 7 days of them being an unverified director and 7 days of it being a criminal offence, I think the money laundering legislation tends to be fairly black and white. I think firstly, yes, you will have had a crime that has been committed. So you've got suspicion that for 7 days the director was committing a crime. And I think that of itself will probably be enough to taint those funds as being proceeds of crime. So I think, yes, you probably are likely to have to put in a suspicious activity report and to ask for a defence against money laundering. Certainly you should report it to your anti-money laundering officer and let them decide what they're going to do. Amanda, if you are your firm's anti-money laundering officer, that's probably not the answer you want me to give, I'm afraid. And I think now we have reached the end of the questions that have been asked so far. If you've got any more questions, please do email them through to me and I will do my level best to try and answer them. And I will now just give you the promised list of dates for your diary. The first one of these is the next coffee break briefing, which is on the 9th of February next month, and I'll be talking then about what's different about LLPs, and I might just mention the new Companies House rules and how those might apply to LLPs as well. There's an R3 regional meeting at a New Forest pub, the Empress of Blandings, 3 days after the coffee break briefing on Thursday, the 12th of February. I think the invitations should be coming out from R3 for that in the next few days. Please do put that in your diaries. It's an evening meeting. I will be giving a short presentation on bankrupt shareholders. 2 local eminent solicitors will also be making presentations, and at the end of it there'll be a chance to hang on and have a bite to eat there, and the food is actually rather good at the Empress of Blandings, so very much recommend that. I'm also involved with the R3 Southern Forum, which is in London on Thursday the 18th of March. There's a really good programme for that that's under development, so do write that date in your diary and look out for when the booking details of that come through. And the other date from this list I'm going to highlight for you is Friday the 5th of June, which is Fretton's 4th annual insolvency conference, which will take place at an as yet secret New Forest location. Last year's conference was an absolutely fantastic day. I thoroughly enjoyed myself. I think most of the delegates there also enjoyed themselves, which is even more important. So yes, please do write that in your diary. And with that, I will say thank you all very much for participating today. See you again in a month's time. Hope to see you at the Empress of Blandings. Hope to see you in London. I hope to see you in June. Thank you all very much and goodbye.